Hello guys, welcome back to our channel and welcome back for another lecture in our channel. So today we're going to be talking about the fundamentals of criminal investigation. So the fundamentals of investigation is a very wide and broad field in the course of criminology. So I'm just going to set the parameter and we're just going to be talking about three specific topic, and those are number one, the definition of criminal investigation, and then we're going to be talking about the three I. We term this as the three I's of criminal investigation. For other references, they called it the tools of an investigator in gathering facts. Anyway, I'm basing my lecture on the PNP Manual on Criminal Investigation Revised 2011. I'm not sure if this is the latest, but I do believe there has been a revision in year 2015. But so far, I think this is still pretty much reliable. And the other topic that we will be talking is the phases of investigation. So if you're in with those topic and if you're looking for a discussion on those topic, then you should stick until the end. Okay, so let's start the discussion already. First, let us define the term investigation. So what is investigation anyway? Investigation refers to the collection of facts to accomplish the threefold aim. When we talk about the threefold aim, it refers to the major goal of conducting criminal investigation. So, what are those? Number one goal is to identify the suspect. It means we must establish the identity of the suspect. Second is to locate the suspect. So, after identifying or after establishing the identity of the suspect, it is pretty much obvious that the next move that the investigation process should do is to locate the suspect. And after the suspect has been located already, then we need to provide evidence to prove his guilt. That's how criminal investigation work. Okay? It will start in establishing the identity of the suspect whenever a crime has been committed. And after the identity of the suspect has been established, we proceed into locating the suspect. And if we located the suspect, I do believe that the next move that should be conducted is, of course, to apprehend the suspect. Now, when the suspect has been apprehended, let us now look into prosecuting the case and providing evidence to prove the guilt of the suspect. Okay? So those are the aims of conducting criminal investigation. So now let's proceed to the six cardinal points of investigation, meaning what is the responsibility of the criminal investigator in conducting criminal investigation. So criminal investigator, I forget to mention, the person who conducts criminal investigation is termed as the criminal investigator. Now, what is the duty of the criminal investigator? So we have here six responsibilities that the criminal investigation must perform. What are those? Number one, let's talk about the responsibility of the investigator to determine what specific crime has been committed. Okay, so this is a very technical matter. Why is it technical? As you can see, for ordinary individual, if there is a person who was killed, then basically that's the act of killing. But in legal term, a simple act or an act of killing may be classified into many or different classifications. So we have case of homicide, we have a case of murder, we have a case of um, parricide, things like that. So the point is that as the criminal investigator, he must identify what specific crime has been committed. There can be a problem with this if the crime that has been committed was not properly identified, meaning there is a tendency that the criminal investigator will file a case to the prosecution and apparently to the court. However, the crime that has been filed to the court is not really the crime that was committed. So things like that, like for example, the criminal investigator filed a case of homicide, then it appears that the crime that has been committed technically is a crime of murder or a crime of parricide. So this can be a technical issue that will make the prosecution of the case go slower. So there might be some delay. Worst case scenario, the case will be dismissed and justice will not be given to the victim. So, those are the things that we are trying to avoid by carefully identifying what crime has been committed. It is an important duty of the criminal investigator to determine what exactly the crime that has been committed and what crime should be filed to the court. So, that's the first duty of the criminal investigator. Second, how the offense was committed. This is also important. As we have stated, there can be some technical things that will become an issue in here since some of the crime that we mentioned or some of the methods on how we are establishing what crime has been committed has something to do with the manner on how the crime has been committed. So let's say, for example, the crime of killing has been committed through the use of poison, through the use of locomotive, through the use of a bomb or any other incendiary device. So, do you think that that circumstances on how the crime has been committed will affect the crime that has been committed? So, do you think that the methodology on how the crime has been committed will matter in filing an appropriate case to the court? The answer is yes, of course, because under the Criminal Law Book 2, it mentions there that if a crime or an act of killing has been committed in this manner, the case that should be filed is like this. So, if the act of killing has been committed with the use of incendiary device, that may fall under the case of murder. So that's another case, or that is a different case to the homicide. So basically, that will show the importance of determining the procedure on how the crime has been committed. Another thing that we must also consider with regards on to determining how the offense has been committed was the fact that it will help also the investigator in achieving the first of the major goal of conducting criminal investigation, which is to identify the suspect. You know, there is a term in law enforcement that has a connection with this, and we call that the modus operandi, or in English translation, the mode of operation. Mode of operation refers to the manner on how the crime has been committed, because there are criminal groups or individuals who commits crime in a recognizable pattern. So if a certain crime has been committed in a recognizable pattern that can be identified into some organization or some person, then we have already a clue or a lead on who committed the crime or in establishing the identity of the criminal. So let's say, for example, the modus operandi of the Laglag Barya gang. So if a crime has been committed in that manner, so we know already who is responsible for this. We have already an idea on who are the persons that probably might have been involved into this crime due to the fact that their mode of operation, the manner how they committed the crime, is recognizable to a certain group or to a certain individual. So that's the importance of the second of the cardinal points of criminal investigation. Third, we need to establish who committed it. The criminal investigator must establish who committed the crime. I do believe that is very much important. Why? Because of course, one of the goal of criminal investigation is indeed to identify the person who committed the crime. And also, as the criminal investigator, it must be his responsibility to determine who the person committed the crime. as we cannot file a case if we don't have any suspect or any accused. Okay, so it's very important that the criminal investigator must do or must collect information or provide evidence to prove the identity of the suspect. Next of the responsibility of a criminal investigator is to determine where the offense was committed. Again, this is a very technical matter. Why? Because, criminal investigation has its own protocol, and most likely they adhere to the protocol of territorial jurisdiction. So the individuals or the investigator who shall handle a certain case, who shall investigate a certain case, must be the person that has jurisdiction over the place where the crime has been committed. So another element of filing a case in the court is territorial jurisdiction. It matters most. It's very much important because if you filed a case in a court that has no territorial jurisdiction over the crime that has been committed or over the place where the crime has been committed, then there's a tendency that the case will face dismissal. So it's an important thing also in the field of criminal investigation. Okay. Next is when it was committed. Why is it important to determine when the crime has been committed? Relatively technical term. Why? Because there are the what we call prescription of penalty or prescription of offense, wherein the criminal investigator must determine if the case will still push through, looking forward to court presentation and court trial. So it's very much important to determine when the crime has been committed and establish whether the crime has already prescribed or the crime can still be filed into the court. And the last thing that the criminal investigator must also prioritize is to identify the reason why the crime has been committed. This is an important question that will answer the motive of the criminal in committing the crime. And upon knowing the motive, I do believe that is very much important also in the court presentation wherein you need to establish the degree of liability of the person who has committed the crime. In the criminal law book when they're talking about the circumstances that might affect the criminal liability of the person, such as if the person committed a crime because of self-defense that will justify the crime that has been committed, or if the crime has been committed because of some unforeseen incident, okay, or if it happens that the person who committed the crime has no criminal intent but the crime has been committed. Those things matters in determining the level or degree of the guilt of the accused. So it is very much also important also to determine the reason behind the commission of the crime. So those are the 6 cardinal points of investigation, or those are the duties of the criminal investigator. Okay, let's proceed to the next topic that we have. We have here the 3 I's of criminal investigation, or in other reference, they call that the tools of an investigator in gathering facts. So, how can we gather, or how can the investigator gather facts that will help him establish number one, the identity of the suspect, number two, the location of the suspect, number three, the guilt of the suspect? How can he be able to collect facts that will that will help him in achieving the goal of criminal investigation? He may resort into different tools, and these tools are the investigative tools that a criminal investigator must use. What are those? We have here the first one, information. What does it mean by the word information? Information refers to the data gathered by an investigator from other persons, including the victim himself. Okay? So information refers to all data collected by the investigator relative to the crime that has been committed. And his primary source of data or facts will be the victim himself. But other than that, the criminal investigator may result also in gathering information through the use of public records, through the use of private records, through the use of modus operandi files. So when we talk about public records, these are the information or data that can be collected openly since it is pretty much available to the public, such as, for example, CCTV videos or barangay CCTV videos or other information that may be considered as public, such as, for example, you need to establish the age of the victim since you wanted to justify that that is a case of child abuse or a case of sexual assault, so on. So, what evidence or what information can you use to establish that the victim is indeed a minor in order for you to proceed into filing a case of child abuse or a case of sexual assault? So, you can use the birth certificate of the accused that can be readily available if you're going to ask for a court request in order for the Philippine Statistic Office to provide you the necessary information in order to prove the minority of the victim. The birth certificate that you will be collecting from the Office of the Philippine Statistic Authority can be considered as a public record. So with that, you have already an information gathered through the use of public records and many other documents that can be considered as public. And it's not only limited to documents, it may also involve CCTV footage. It may also involve even a simple logbook or incident report coming from different agencies of the government. Another thing is the private records. So these are information that is within the custody of private person, private organization, private companies, and so on. So if we're talking about data that are within the custody of a private organization, private individuals, then we can consider that as a private record, such as, for example, a bank transaction. If the bank is a private bank and you need to have the details of the bank transaction of a certain person or of a certain group, then you may request for the court to issue a summon in order for that private bank to provide the information needed by the investigator in order to help him establish the truth behind the incident. So that is an example of a private records. So we have also modus operandi file. I made mention of the term modus operandi already. So what does it mean? Mode of operation. Where can we find this? In different law enforcement agencies that keep tracks on the different way on how crimes are being committed by a certain group or by a certain individual. That is also one of the possible area where the criminal investigator may gather information. Next of the tools that an investigator may use in gathering facts is through the utilization of interview slash interrogation. So what does it mean by interview slash interrogation? Interview refers to the skillful questioning of witness and suspect. As we have stated, the primary source of information when it comes to crime is the victim himself, and we may also conduct an interview to the witness and to the suspect. So the process of collecting data through face-to-face communication with the person involved in that crime is known as interview or interrogation. You know, in technical terms, interview and interrogation is different. Interview refers to the simple questioning of a witness or the suspect. So interrogation refers to the skillful or technical way of questioning in order to elicit information from uncooperative suspect or uncooperative witness. But basically, since we're just talking about the three eyes of investigation, I think we might leave it that way. So next tool that an investigator may use in gathering facts is the use of instrumentation. So, what does it mean by the word instrumentation relative to the tools of an investigator in gathering facts? So, an investigator may rely to science in order to gather information to achieve the goal of conducting criminal investigation. What are those science? So, we have here the different investigative science that can be utilized with. We have DNA examination. That's very much useful in the field of criminal investigation, especially in establishing the identity. We have also fingerprinting science. We have lie detection. We have forensic ballistic, we have forensic photography, and many more criminalistic subjects. Okay, so those are the different tools that an investigator may use in order to gather data. Now let us proceed to the last topic that we have. We have here the phases of investigation. So what are the phases of criminal investigator? So what are the phases of criminal investigation? Basically, we have three phases that is based on the threefold aims of criminal investigation. So as we have stated, the first thing that an investigator must do is to identify the suspect. How can the investigator identify the suspect? Number one, through confession. Confession from whom? Of course, from the suspect or the accused. If the suspect or the accused had admitted that he is indeed the person who committed the crime, then you establish already the identity of the perpetrator through his own confession. So, confession coming from the suspect himself admitting that he was indeed the person who committed the crime. Okay. Another way also of identifying the suspect is through the testimony of eyewitness. Okay. So if there are some individuals who witness when the crime or who witness how the crime has been committed and who committed the crime, then I think that's very useful way of identifying the suspect also. Okay. Another way of identifying the suspect is through the use of circumstantial evidence and associative evidence. So when we talk about circumstantial evidence, these are not direct evidence, but if they're going to combine them together, it will make sense and it will pinpoint who committed the crime, therefore establishing the identity of the suspect. Okay. What about associative evidence? So we have different evidence that may help the investigator in identifying the identity of the suspect, such as, for example, fingerprint that may be used in identifying the suspect. If the fingerprint of a certain person is found on the crime scene, then that fingerprint will associate the person to the crime that has been committed. Because why is it your fingerprint in the crime scene? Or why is it your footprints in the crime scene? So it will establish that the person whose fingerprint or footprints appears in the crime scene might have been in that crime scene. Although it does not directly prove his guilt, but then it associates that person to the crime scene and therefore to the crime. Okay? So that is some of the way the investigator may establish the identity of the suspect. And this is just on the phase one of the criminal investigation. So the phase one, identify the suspect. Let's proceed to the phase two. So phase two focuses on locating and apprehending the suspect. So if we're done with the phase one, meaning we already established the identity of the suspect, then let us proceed to phase two, wherein we need to locate the suspect and apprehend the suspect. So that would be easy already as long as we are sure with the result of the phase one, meaning we have already the name of the suspect. Then I do believe that if you have the name of the suspect already, it is already easy to establish the location of the suspect based on the available information that we might stumble upon if we establish already the identity of the suspect. I do believe that part one or phase one is the most crucial one and the most hard phase of criminal investigation because we are starting with nothing. But if we already have information regarding to his identity, then I do believe it is easier now to locate and apprehend the suspect. Okay? So phase 1, identify the suspect. Phase 2, locate and apprehend the suspect. Phase 3, relative to the third goal of conducting criminal investigation, which is to provide evidence to prove the guilt of the suspect. So the phase 3 of criminal investigation talks about the gathering and providing evidence to establish the guilt of the suspect or the accused. Okay? So we must remember that in proving the guilt of the accused in court, we must first establish, or the investigator must first establish that there is indeed a crime that has been committed. Does it make sense? Of course it does. There is no crime or there is no criminal if there is no crime that has been committed. How can you convict a certain person of a crime that has not been committed? So let's say, for example, I am accused of committing homicide, but then the person whom you're accusing me to have killed is not dead, or his death cannot be established. Therefore, there is no point for me to being prosecuted or to be punished if we cannot prove that the crime has been committed. So that is the sense of this. The investigator must establish before anything else that a crime has been committed. Okay? Then next, the investigator must identify the accused and associate him to the crime. So if a crime has been established to have been committed, you have now the suspect. And that suspect must be carefully identified and should have been associated to the crime that has been committed. How did he become a suspect? How did he become the primary accused of the crime? What is the relationship of the crime that has been committed to the person who was apprehended? So the investigator must establish the connection between these two. Okay? And next is the investigator must provide a competent and credible witness. So if there is a crime that has been committed, there is an accused, what remains there is they must have evidence to prove the guilt of the accused. And how can they prove that? Either by collecting information relative to the crime that will help them in establishing the guilt of the accused, or by having simply a credible witness who will testify in favor of the prosecution and help them in establishing or prosecuting the accused. Okay, so that is also one of the important responsibility of the accused. And also the investigator must take into consideration that all of the physical evidence that will be presented is properly identified. And then the investigator must know the elements of the crime. You remember in our previous discussion, we made mention that the investigator responsibility is to determine the specific offense that has been committed. We made mention of the word specific, as that is very much important. It is very much important that the criminal investigator must be familiar with the different types of crime and the elements of crime in order for him to determine what the specific crime that has been committed. Let's say, for example, the case of taking someone's belongings, like snatching. How can you classify that? Is that a theft or is that a robbery? So a good investigator who has knowledge with regards to the different elements of crime can distinguish theft from robbery, and can distinguish homicide from murder, and many more. So those are the important notes that we must take into consideration in relation to the phases of criminal investigation. Okay? Just a short review, we have here the threefold aims of criminal investigation, which is to identify the suspect, to locate the suspect, to provide evidence of the guilt of the suspect. We have also here the cardinal points of criminal investigation. That is, number one, to determine what a specific crime has been committed, how the offense has been committed, who committed it, where was the offense committed, when it was committed, and why it was committed. And then we have here the three I's of investigation, or the tools that an investigator may use in gathering facts. Number one, information. Number two, interview. Number three, instrumentation. And the phases of criminal investigation: phase one, that is to identify the suspect; phase two, to locate and apprehend the suspect; phase three, to gather evidence to prove the guilt of the suspect. Okay, so that's it with regards to this lecture. I do hope you learned something from this lecture. If you have question with regards to this, comment it down on the comment section and I will try to provide answer as soon as I can. That's it for today. See you guys on the next video.